Hi, this is John Goodman, recording one of my videos in the series of videos where we're talking about managing the risks of coronavirus. And in talking about this, this topic is about my more specific suggestions about how real estate brokers, buyers and sellers manage the risks that unforeseen things will come up and that may cause one party or both parties to want to get out of the transaction or at least delay the transaction. That's what we're talking about. So I recorded a prior video that hopefully you've watched. If you haven't watched it, I encourage you to watch it. It's about all the tremendous complexity that could go into these clauses. And one thing I suggest in those clauses is that I know that very few of your clients will follow through on this suggestion, but you have a trail of recommending that your client talk to a lawyer about managing COVID-19 risks. But your client chooses not to have the lawyer draft the clause, and they are looking for you for an approach to manage the risk for the buyers. The way I would prefer that buyers manage the COVID-19 risk is to set up a contract so that if the buyer happens to want to default on the contract, the consequences for the buyer are very minimal. That sort of approach gives the buyer an out until the end of the transaction, essentially for any reason at all. And it doesn't have to say so. In other words, what I'm envisioning is buyers submitting offers that are liquidated damages contracts. The seller's only remedy is to get the buyer's earnest money, and the buyer's earnest money is a small amount, say like $500 or $1,000, whatever is small for that particular transaction in a residential deal. Another way that the buyer can manage that risk is, in Colorado, the contingencies for buyers give the buyers the ability to exercise those contingencies in the buyer's sole and subjective discretion. And so if those contingencies are late enough in the transaction, and for example, as late as the closing date, then if the buyer has, for example, a loan termination deadline and an inspection objection deadline, the same day as closing, that gives the buyer a lot of power to terminate the contract and get the buyer's earnest money back. Now, I know what you're thinking, John, that gives the buyer too much power. If I'm the seller, I don't want the buyer to have the whimsical ability to terminate the contract until the end of the deal. But remember that language, ink on a page, or ones and zeros in a computer do not make the buyer close. And if the buyer doesn't want to close, regardless of what the contract says, the buyer is unlikely to close just because there's contract language requiring them to do so. And then you have to ask yourself, even in normal times, is the seller going to be willing to incur the expense, the inconvenience, and the risk of having to pay the other side's attorney's fees to enforce the contract? I'm suggesting that the COVID-19 risks are significant enough that it might be reasonable for the seller to rely on the fact that the buyer is doing things to put skin in the game, like applying for a loan, paying for an appraisal, paying for credit reports and the like. And the seller doesn't have recourse at the moment to the court system to enforce a more nuanced approach. Now, for sellers, that approach I just mentioned, that is having very small amounts of earnest money, having contingencies that expire very late in the transaction, if not as late as the closing date. That solution does not work for sellers who are nervous about themselves wanting out of the contract later. So what do those sellers need? So the first thing is to recognize that the seller's position is different because there are no contingencies in the contract that excuse the seller from performing, subject to certain esoteric exceptions like seller carry financing that are not relevant to this video. So because the seller doesn't have any contingencies, making contingencies at the end of the deal does not protect the seller. What the seller needs is a clause that says to the effect that, regardless of whether I terminate the contract or not, regardless of whether I breach the contract, regardless of whether the seller breaches the contract, the buyer's only remedy is to get their earnest money back, to get their hard costs back, and then maybe some other consequence, some other penalty for the seller. Like the buyer doesn't just get the buyer's earnest money back, the buyer gets 110% of the buyer's earnest money back. Or maybe the buyer gets 150% of the buyer's earnest money back. Or maybe the buyer gets 200% of their earnest money back. That is the approach that I am suggesting for sellers. That's it. I have one more video to record, and the one more video to record is reflecting of the notion of those of you who are listening and saying, John, I get everything you just said. I get everything you just said. But that's not the way the world is right now. What the world wants is a feel-good COVID-19 clause. I need a clause that works from the brokers who don't understand these notions, as well as people who have the good taste to watch your videos, John. So is there any other alternative? Is there one clause that works for both the buyer and seller that might be widely accepted in the marketplace? And my next video will talk to you about how we might combine force majeure notions with some things I've already mentioned into that potentially one clause. Remember, we live in a complex world. Be careful out there.